Welcome, everyone. I'm Barb Van Hoy, Policy Analyst with the city's Community Development Division, and it's my pleasure to welcome you to the first Renter Rights 101 workshop of 2021. Thank you for being here. These events are produced in partnership with Colorado Legal Services, the Pikes Peak Library District, and the Justice Center, all of whom you'll hear from shortly. Before we dive into the program, I did want to just share a little bit about the virtual format and the meeting controls. So in this Microsoft Teams live presentation, everyone is muted. And you should be able to click on a little gear icon in the bottom right hand of your corner which will enable closed captions, and there are several language options. You also can type questions through the Q&A box. Again, you should be able to see that option on your screen, perhaps the lower right hand. And we will be sharing the slides of today's presentation by email. We do absolutely encourage your questions as we go along. Please put your questions in the Q&A box. And for the most part, we will have time to answer those questions at the end of the presentation. So, in order to receive the slides, we know that many of you signed up for this event through the Justice Center's website on the Renters Rights 101 page. If you did not sign up that way for this event, but you would like to get the slides, you'll need to go back to that page, which we'll be putting in the chat very soon. It's the Justice Center, cos.org, and click the Renters Rights page. And if you enter your email address there, we will send you the slides. Tonight, for this event, our partners will share some great resources that they offer in the community, and we'll hear from an experienced attorney who will share legal rights of renters. And we'd also love to know who you are, who is here. So please, if you would, you can use the Q&A box to let us know if you're a renter, if you are a landlord, why you're here. Is there some particular concern that you have, or just what's important to you that brought you to the Renter Rights 101 presentation tonight? So please do tell us who you are. And in the meantime, I will tell you about why I'm here. So I'm with the Community Development Division. And even before the pandemic exacerbated the housing crisis, affordable housing was one of the top concerns here in Colorado Springs, as well as almost every city in the United States. It's a top priority for our mayor, for sure, and an issue that the Community Development Division dedicates almost all of our time to day to day. The Community Development Division manages the City of Colorado Springs entitlement funds from the U.S. Department of Housing and Urban Development. We are charged with preserving affordable housing, preventing homelessness, and improving struggling neighborhoods. By providing practical resources for renters, by helping to organize these events and other activities, we help achieve these goals. Ensuring renters and landlords know their rights and their responsibilities helps us prevent unjust evictions and to keep people housed. So now I am going to introduce one of our partners, Deborah Hamilton. She is the Strategic Services Librarian who oversees the law and legal resource collection for the Pikes Peak Library District. She is chair of the board of directors for the Justice Center and is also a member of the Access to Justice Committee for Colorado's 4th Judicial District. Deborah's book, Helping Library Users with Legal Questions, Practical Advice for Research, Programming, and Outreach is scheduled to be published in July 2021 by Libraries Unlimited. Originally from Idaho, Deborah is happy to have called Colorado Springs home for the past 6 years. Deborah, do you want to, if you haven't already, shared your screen and I can put that up?
Sure, yeah, let me do that.
Oh, you're muted.
Okay, can you hear me and can you see my screen okay?
Okay, and I believe your slides are up.
Okay, and can you hear me okay?
We can hear you, Deb.
Okay, thank you. All right, hi everyone, my name's Deb Hamilton. As Barb mentioned, I'm here from Pikes Peak Library District. If you're not aware, the Pikes Peak Library District actually has a legal research collection located at our downtown location, the Penrose Library at 20 North Cascade. So you can go in now to that building and look at the books on the shelf if you'd like to. You can also hop on a computer, use our internet and some of our online resources. But what I'm going to show you tonight are just a few things that are available on our website that you can access from home or wherever. And so we're going to begin at the main library webpage. The address is ppld.org, or you can also just do a Google search for the library. Over here, we have a bunch of research guides. So I'm just going to click here where it says research. And that's going to open a new page. And I'll scroll down and locate law and legal resources. Now on these guides, there's actually quite a bit of information that we don't have time to go through all of today, but I just want to highlight a couple of things that I think will be relevant to you after you view this presentation that we're about to see. So a few things here. If you're interested in other legal programs, you can check out this box here, but I'm going to scroll down to the bottom of this page to where it says featured sources. Speaking after me is Britt Kwan from the Justice Center. She's going to talk about some of their services, but here I just want to highlight is a link to get more information about their clinics. And even if you go to the clinic page, you can still find information about their other services through the website there. Clinton Albert, who will be giving the presentation later, he is from Colorado Legal Services. So there's a link to their organization. And then Clinton will probably be talking a bit about some of what's in the Colorado revised statutes. So those are going to be the state laws. And so if you want to view those for free online, there's a link to do that there. And then another one I want to highlight down here is this Colorado Judicial Branch link. If you go onto this page, along the top, you'll see a link for self-help and forms. In there, you can find information about housing cases, so you can get all the paperwork if you were a landlord trying to file for an eviction, but it also has really good information if you are a tenant responding to an eviction. So it'll give really good directions about what you need to do and how to respond and all of that kind of stuff. They've done a really good job of putting pretty easy to understand directions with a lot of their forms. And I even noticed today in that housing cases area, they have a section now on unlawful evictions, and it looks like they'll be adding some more forms there soon. So you can get information there as well. And then the last thing I just want to mention is the library also does a free legal clinic over the phone right now because of COVID. Normally we do it at our Fountain location, but I think it'll be a little while till we do it in person again. But you can sign up with me. My contact information is right here. It's the first Monday of every month from 3:30 to 5. And I do have a few slots still available for this coming session on Monday. This clinic you do need an appointment for just because we only have one attorney. Britt will talk about the Justice Center clinics where you can just call in during the clinic time. And then last but not least, if you need to get a hold of me, here is the building I work in, my telephone number, and you click on that to get to my email address. And so I will be putting a link to this page in the chat. But if you have any other questions, feel free to put them in the chat or just get in touch with me whenever it's convenient for you. So I'm happy to be here and welcome everyone. And Barb, I am all done with my piece.
Great. Thank you so much, Deb. So next, I am pleased to introduce Britt Kwan. She is the Executive Director for the Justice Center. Britt has 9 years of experience in the nonprofit industry and is passionate about leveling the playing field. When she's not running legal clinics or answering emails, you can find her hiking with friends or talking with chickens, with her chickens. Okay. And then Britt, can you share your slide and I can put that up there?
Is that working, Barb?
I'm not seeing it just yet. Oh, there it is. And
okay.
Now it should be almost live. Okay, go ahead. Thanks.
Okay. Hi, everyone. My name is Britt Kwan. I'm the Executive Director for the Justice Center. We are a legal aid nonprofit in the Colorado Springs area, but we serve El Paso and Teller counties. A couple of our programs I wanted to let you know about that are relevant for tonight. First, like Deb mentioned, we have some free legal clinics. So the main one we're doing right now during COVID is called Call a Lawyer. It happens every Wednesday night from 7 to 9 p.m. You can call the main number on our website. And during that time, it is a special free legal clinic. So when you call in, your call is first screened by a call screener, which is normally me and another volunteer. And then after that, once we figure out what type of question you have, we connect you to a lawyer and you can talk with them one-on-one, anonymously and confidentially, and they can give you some brief legal advice and hopefully some next steps. The other program I wanted to let you know about especially, we actually have some educational videos created by a lot of lawyers and other professionals on our website, and they are all pertaining to housing issues right now. So we have videos on what to do with your assistance animal and assistance animals in housing, videos on how to request a reasonable accommodation or modification, videos on hard conversations with your landlord, what a security deposit is and what you need to know about it. So if you're interested in those are also available on our website. We do also connect qualified applicants to free and reduced cost lawyers. So if you're interested in that, you can head to our website. The link is on the screen, and we'll probably be dropping in the chat too, so you can follow it there. Yeah, if you have any questions, let me know. I think that's all I have, Barb.
Thank you so much, Britt. All right. So now I am especially pleased to introduce Clinton Albert. Clinton is a housing attorney with Colorado Legal Services, where he has served for 3 years. At Colorado Legal Services, his caseload is made up solely of landlord-tenant matters and covers a broad range of legal issues within that area. He has been presenting the Renters' Rights Series since 2018, and when not practicing law, you will likely find him in the outdoors hiking and climbing. And give me just a minute, Clinton, and I will share your slides. And I believe they are up. Thank you, Clinton. Take it away.
All right. Good evening, everybody. I'd like to thank you all for attending this evening. My name is Clinton Albert. I'm an attorney with Colorado Legal Services, and tonight we'll go through, we'll cover a broad range of topics, and we will save some time at the end for questions. But if you have any questions along the way, feel free to put them into the chat so we can answer them later. Just a few things to keep in mind as we start. This presentation is for informational purposes only. Housing issues require a thoughtful analysis of the facts and the law. And also in 2020 and 2021, the ever-changing COVID protections have changed on nearly a monthly basis, so that adds just another case-by-case analysis requirement on housing matters. If you are a low-income community member or a senior citizen and are facing a housing issue, you may contact Colorado Legal Services at 719-471-0380. It says in person, but your best bet's going to be either on the phone or online at www.coloradolegalservices.org. So before we get into the bulk of tenant protections and some other matters, I wanted to start with the current state of COVID-19 protections. Colorado, at the state level, in 2020, the eviction moratorium has expired at this point. different rules are going to apply to different documents depending on the date on those documents. Even if it is an older document, even if an executive order has expired, that executive order would still apply to certain documents. For example, demands for payments are still subject to the executive order or orders that were in effect at the time that the demand was served. In 2021, currently at the state level, there's Executive Order D 2020-307. It bars late fees through January 31st, 2020, and it also adopts a federal law here. So what is this Section 502 of the Consolidated Appropriations Act of 2021? Well, that was the act in the most recent stimulus package, which extended the CDC eviction moratorium through January 31st, 2021. Now that's at the state level, and this Executive Order 307 is set to expire at the end of January. Governor Polis may issue a new executive order, but at this time he has not done so. Now at the federal level, we have the CDC eviction moratorium that had first gone into effect in September of 2020, but recently it has been extended through March 31st, 2021. The moratorium prevents landlords, owners, or residential property or other persons from evicting any covered person. Now, who is a covered person? It's going to be any tenant, lessee, or resident of a residential property who provides to their landlord is a declaration under penalty of perjury. The covered person declaration states a few things. It states that the individual has used their best efforts to obtain all available government assistance for rent or housing, that they expect to earn no more than $99,000 in annual income for calendar year 2020-2021, or $198,000 if you're a joint tax filer, if you are not required to report any income, or if you received a stimulus check pursuant to 2201 of the CARES Act. The individual is unable to make a full rent or housing payment due to a loss of household income, wages, hours, layoff, medical expenses. The individual is using their best efforts to make timely partial payments that are as close to the full payment as possible, taking into account their individual circumstances and non-discretionary expenses, food, medical costs, things of that nature. Finally, that if evicted, the individual would likely be rendered homeless or force them to move into a closer shared living or congregate living settings. Here is what the CDC declaration form. There's a link here on the slide, but also if you were to Google CDC eviction declaration or any kind of web search, you would likely be able to find this, as this form is available on the website. So a big question that I've encountered is, does this moratorium prevent all evictions? No, it does not. Evictions can still proceed for criminal activity while on the premises, threatening the health or safety of other residents, damaging or posing an immediate and significant risk to damage of the property, violating any housing code, health ordinance, or any regulation relating to health or safety, or really any other kind of lease violation, any other lease violation except for non-payment. The moratorium does not waive rent. Tenants are still required to pay their rent, but they cannot be removed. They cannot be evicted for non-payment during the moratorium. Once the moratorium ends, you're still going to be responsible for any unpaid rent that has kind of built up throughout the period of the moratorium itself. And as indicated earlier, it's currently set to expire on March 31st, 2021. It is possible that this is extended, so it would be very much in your best interest to keep yourself kind of informed as to any kind of new developments as to new housing protections for tenants in 2021. Here is the full text of the original order and the press release for extending the moratorium through March 31st, 2021. So before we kind of get into the rest of the presentation, I just wanted to check for questions real quick.
Clinton, somebody asked, what age is somebody considered a senior citizen for the purposes of CLS? And
60 years old. That's a good question. Thank you for asking. Seeing no other questions in the chat at this point, let's keep going. So, before we're moving into a new residence, it's an exciting time. It's a new start. It's a new home. But there are a couple things that I think are important to keep in mind before you're settled into your new home. First is that there's a new law in 2021 in Colorado, which prohibits discrimination based on the source of income. So what this means is that landlords are no longer able to deny a person a rental property based on the source of income. Now, what the source of income, the big part, in my opinion, is that it's going to be that last line there on this slide, which indicates that it is source of income includes income or rental payments derived from any government or private assistance, grant, or loan program, meaning that landlords are no longer able, there are some exceptions, but for the most part, landlords will not be able to deny a possible tenant a house based on the source of income, meaning that landlords can't advertise or reject somebody because of a housing assistance voucher. And there is a link to the bill, the law which adds that income discrimination ban. So something to keep in mind right off the bat is to try your best to put everything in writing. A lease is a contract between you and your landlord. It does not matter if there was any kind of pre-existing relationship, if this is somebody that you've known for 30 years, it's your pastor, it's your boss, it's a business relationship. It is the best practice to put that business relationship into writing. Oral leases are valid, but they are more difficult to prove, especially if there's some kind of allegation that I am not responsible for this, if there's nothing in writing saying who's responsible for what during the tenancy. Oral leases are presumed to be month to month, and there cannot be an oral lease that it can be longer than 2 years by law. So moving on, we're still kind of, before we get into a new residence, well, we've got to apply for one. So the Rental Application Fairness Act covers what landlords are able to consider when assessing an application and application fees. So application fees can't be charged unless they're used to unless the entire amount is used to cover the cost in processing an application. Costs are either the actual expenses taken in processing an application or the average expense when a landlord has to process multiple applicants. Landlords cannot charge different application fees to different applicants, and landlords must provide the applicant with a disclosure for how much they think the application is going to cost to process, how much they think it's going to cost, or how much it will actually cost to process the application, and also a receipt for the application fee itself. Landlords must make a good faith effort to return any remaining amounts to the applicants. So, what kind of rental or credit history can a landlord consider as they are processing a rental application? Well, for only the past 7 years of rental or credit history. So if there's an eviction or a bankruptcy from 9 years ago, that cannot be taken into consideration when you're applying for a new home. And it cannot be a reason to deny you a new home. What about criminal history? Well, landlords cannot consider arrest records from any time. What about criminal convictions? Well, they can consider criminal convictions that are 5 years or newer. But if a conviction is older than 5 years, a landlord cannot consider that conviction unless the conviction is generally related to methamphetamine, distribution, production. If it's a criminal offense that requires somebody to register as a sex offender pursuant to Colorado revised statutes, if it's a homicide related criminal conviction, or if it's a stalking conviction. So what happens if you apply for residence and you are denied? Well, the landlord has to provide you with a written notice of that denial, and it has to include the reasons for the denial, and the landlord has to make good faith efforts to get this back to you as the applicant within 20 calendar days of their decision to deny your application. What happens if the landlord does not follow the law when it comes to rental applications? Well, as an applicant, you can seek 3 times the amount of the application fee, plus any court costs and reasonable attorney fees. You must give the landlord, however, a notice of your intention to file legal proceedings at least 7 days before filing the action. This gives the landlord an ability to cure the violation. If, for example, a landlord is saying, well, I'm not renting to you because you have a theft conviction that's 7 years old, then that would be an improper denial, because the landlord would not be able to base that on a criminal conviction of that age. If you are an applicant and you're denied, but you file a meritless claim in court, then if the landlord prevails, then the landlord will be able to seek court costs and attorney fees in that matter. And there at the bottom are the Colorado revised statutes which cover the Rental Application Fairness Act. So once you get approved, now we've gotten in, we've applied, we've been approved, and now it's time to sign the lease. One of the biggest things that I cannot stress enough is to read your lease. I know that they're long, I know there's a lot of fine print, but it's critical at this stage that you read through and have an understanding of what the lease is. For example, what's the length of the lease? Is it a month lease? Is it 1 year? Is it 2 year? Are the proper dates written in? What happens after the initial lease term ends? What's often called a rollover provision? Is that in there? Is it automatic if nobody says anything? What about any late fees, utility fees, any kind of monetary penalties contained within the lease? Because remember, this is a contract that you're signing. It's not, they're not doing you a favor. It's a business relationship that you're entering into. You're going to be paying them money, and in exchange, they're going to be providing you with a residence. What are your responsibilities for upkeep and maintenance around the residence? What are your landlord's responsibilities for upkeep and maintenance? You want to make sure that you have a clear understanding of what your responsibilities are under the lease as you enter into your new home. Other sections to review, notice related section. Specifically, and we'll cover this in just a second, is your tenancy an exempt residential agreement? There also should be some warranty of habitability related sections, such as which appliances are going to be included in the lease, and the email address or electronic portal address for electronic notice delivery for warranty of habitability issues. So what is an exempt residential agreement? Well, it only applies to single family homes, so it can't apply to an apartment or a condominium. And it can only apply to a single family home that is leased by a landlord who owns 5 or fewer single family rental homes. In the lease itself, the landlord has to provide notice that this is an exempt residential agreement and that the 10-day notice period for demands for compliance do not apply to this tenancy. So because it has to be in writing, no oral leases can be an exempt residential agreement. And ultimately, the exempt residential agreements give a tenant 5 days to cure a lease violation instead of 10 days. There are some unenforceable lease provisions. As a tenant, you cannot waive your right to the return of the security deposit in the lease. You cannot waive your right to the warranty of habitability. There is an exception to that, which we will cover later, but there has to be a separate agreement for you to be able to waive any warranty of habitability protections. You can't waive your covenant of quiet enjoyment. You cannot waive your right to a demand for payment for unpaid rent, and you cannot waive your right to the court process for eviction cases. Again, get a copy of your lease. Not only is it important for you to have these records as it relates to your tenancy, because this is your reference for what do I have to do while I'm here? Is my landlord able to do this? Am I in violation of the lease if I do this? Those kind of questions can be answered by your lease itself. So it's really important to get a copy of it. Also, the law requires your landlord to provide you with a copy of the lease within 7 days of you signing that lease. Let's talk about a little bit on receipts. So if you pay your rent or security deposit with cash or money order, you have a right to a rent receipt. If you pay in person, you have a right to a receipt immediately. If you pay by mail and request a receipt, your landlord has 7 days to provide you with a receipt. Again, it's my opinion that it's important to keep a record of those payments and those receipts, because if there's ever any kind of dispute as to the accounting, as to rents that were paid or not paid, you're going to want to have that documentation to show that, no, it was paid. Here is the receipt that you signed showing that you received that payment on that date. Take pictures. When you're first moving into a place, before you get settled in, take the time to document the condition of the residence. Take pictures of everything. Take pictures of something if it's damaged. Take pictures of something if it's undamaged. And then do the same when right before you're about to move out. This documentation, in my opinion, is crucial for security deposit disputes. If you're able to, I know things are a little bit different during COVID times in that a lot of things are done remotely, such as this presentation itself. See if your landlord or your landlord's agent would be willing to do a walkthrough with you of the property. Why is it important to take this extra step? Because together, you and your landlord can identify pre-existing damage, and both of you enter into the contract with the same understanding of the condition of your residence. Tips here. I would be critical. I wouldn't be unreasonable, but I would be critical. You're not being a bother, or you're not annoying your landlord as you're doing a walkthrough to point out that the blinds are broken, this light switch doesn't work, these light bulbs are burnt out. You're paying for this residence, so you have an obligation to let them know that there's damage and that it's their responsibility to maintain the property. This is a business relationship. I can't stress that enough. So that's why it's crucial to be critical as you're starting your tenancy. That way, if there are some conditions issues when you first move in, those are hopefully resolved quickly. Another thing, as you're reading through your lease, take a look to see if there's any reference to additional rules or regulations. These can be additional conditions of your tenancy. And if your lease references additional rules or regulations, or if you sign any kind of lease addendums with those rules and regulations, those are going to be rules that apply to you and your tenancy. And if you break a rule, you could put yourself at risk of an eviction. Certain things, are there quiet hours in the buildings? Is there a grievance procedure for any kind of neighbor disputes that your landlord wants you to follow? It's important that if these rules are laid out, that you follow those rules. Let's switch gears here and talk about the warranty of habitability, especially as, if you've spent the day like I have, you've been seeing it snow all day, and I'm certain that there will be some homes around the city tonight that the heat's going to go out in. But what is the warranty of habitability? Well, first off, it's the promise that your resident is fit for a human being to live in. Now, there are a list of things that by law must be present in your residence. There is a packet, the renter rights packet, which I believe is published on the city's website, and it would be available there, and that list is in the packet as well. Electronic notice. What is electronic notice? Well, first of all, a work order is not electronic notice for the purpose of warranted habitability. So what is an electronic notice? By law, it means a notice by email or electronic portal or management communication system that's available to both a landlord and a tenant. If you send an electronic notice, you must send it to only the email address, phone number, or portal that is specified by the landlord in the rental agreement. So kind of jumping back, this is just a clear example of why it's so important to make sure you understand what's in your lease. Because if you're sending a warranty of habitability demand to an email address that's not the one specified in your lease, there's a chance that a court would find that you never put your landlord on notice of the warranty of habitability issue. So, if your rental agreement indicates that you have to send it to an email address, then you can't send it to a text message. But what happens if your lease is silent on where to send an electronic notice? Let's say you have a 5-year lease from 2017. At that time, there was no ability for a tenant to provide electronic notice, so there's a good chance that the lease doesn't include anything about that. Or an oral lease isn't going to have that information because, well, it's an oral lease. So if your lease is not specific, then as a tenant, you shall communicate with the landlord in a manner that the landlord has previously used to communicate with you. So that means that if there's not a provision in your lease on this is where you send the electronic notice, and your landlord then text messages you, you are able to provide the warranty of habitability demand over text message. Make sure that you keep proof of this delivery. If it is via text message, make sure that you take a screenshot of the message and save it to a safe email account. If it's from an email account, make sure that you try to print out the copy of that email and save that somewhere. So, what are the conditions that are covered by the warranty of habitability? First, there must be sufficient waterproofing and weather protection of your roof, walls, doors, and windows. The plumbing and gas must be in good working order. The running water, the reasonable amounts of hot water, proper fixtures, and connection to the sewage disposal system. There must be functioning heating facilities in good working order and in compliance with the law. Electrical, lighting, and wiring and equipment must also be in good working order and in compliance with the law. The common areas under control of the landlord must be kept reasonably clean. Your landlord must provide an appropriate extermination in response to any reported infestation. I want to take some time to kind of talk a little bit more about infestations, specifically regarding bed bugs. So as a tenant, if you know or you reasonably suspect that your dwelling unit contains bed bugs, then you have to promptly notify your landlord via written or electronic notice about that. And then once you get a copy of that notice, then within 96 hours of getting it, you've got to provide the tenant with a 48-hour notice of your intention to enter the dwelling to inspect it. And you also have to obtain an inspection by a qualified inspector. You may enter that dwelling, that specific unit, or if this is, some kind of apartment building, you can also enter any contiguous unit or attached unit, like a neighbor, for the purpose of inspecting that unit. If the inspection itself confirms the presence of bed bugs, then the landlord has to inspect all contiguous units as promptly as is reasonably practical. The landlord is responsible for all costs associated with an inspection for and treatment of bed bugs. After the bed bug inspection, the landlord has to give the tenant written notice within 2 business days whether or not the dwelling unit contains bed bugs. If the inspector determines that they didn't find anything, the landlord's notice has to inform the tenant that they can still contact the local health department if their concerns remain. If the inspector confirms bed bugs, then the inspector has to provide a report to the landlord within 24 hours. And then again, not more than 5 business days after that inspection, if the inspection says, yep, there's an infestation, the landlord has to start working measures to treat the bed bug infestation. So that's including retaining pest control services. It can't be just handing somebody a can of Raid and saying, have fun. That's not sufficient. So once the extermination service is contracted for as a tenant, you have to comply with the reasonable measures to permit the inspection and the treatment. You can't bar them from entering the property. If they give you kind of a checklist of here's what you need to do to get your residents ready for our treatment, you've got to make sure that you go through and follow the checklist as well. You're going to be responsible for all costs associated with preparing your home for the inspection and treatment, but not for the inspection and treatment itself. So for example, if the treatment requires that you put all of your clothing in a trash bag in the center of the room and you have to go out and buy trash bags, that cost is on you as a tenant. But again, the cost for the actual treatment, that's your landlord's responsibility. If you're living there and you knowingly and unreasonably fail to comply with the inspection requirements or the treatment requirements, then you, as a tenant, you may be liable for the cost of any treatments of your unit and any units around you if that need for treatment arises from your noncompliance. If you refuse to allow somebody to come in and treat your unit and then that infestation spreads, you're potentially going to be responsible for that. Landlords, you can't rent a unit that you know or suspect to contain bed bugs. And if you're on the market and you're looking for a new place, you can ask the landlord whether or not, to their knowledge, they know whether or not the unit contained bed bugs within the last 8 months, or to have the landlord disclose the last date the unit was inspected for and found to be free of bed bugs. What about liability as it's coming to this? We've discussed who has to pay for things. Landlords who fail to comply with inspection and treatment requirements are going to be responsible for the tenant's actual damages for a bed bug infestation. A landlord may apply for injunctive relief against a tenant who refuses to provide reasonable access to the dwelling or fails to comply with a reasonable request for inspection or treatment. That means that a landlord can go to court and try to get a court order to force the tenant to permit inspection and treatment of the residence. If a court finds that a tenant has unreasonably failed to comply, the court may issue an order granting access to the dwelling, the landlord the right to inspect and treat the dwelling, and requiring the tenant to comply with any specific inspection and treatment measures, or assessing the costs and damages related to that non-compliance to the tenant. We're still in the warranty of habitability and the conditions that are subject to it. So, landlords, you also have to provide an adequate amount of outside receptacles for garbage. So if you've got a 50 apartment building, a 50 unit building, and you have a 10-liter trash can for the building, I'm going to go ahead and take a guess that that's not going to be sufficient. There have to be working floors, stairways, and railings. The locks on the exterior doors and security devices on windows that open. The unit also must be in compliance with all applicable building, housing, and health codes, which materially interferes with your life, health, or safety as a tenant. So that kind of gets us a little bit to mold here. Mold is a specific part of the warranty of habitability. It's defined as the microscopic organisms or fungi that can grow in damp conditions in the interior of a building. A residence is uninhabitable due to mold when there is mold that is associated with dampness, or there is any other condition causing the residential premises to be damp, which condition, if not remedied, would materially interfere with the health or safety of the tenant, excluding the presence of mold that is minor and found on surfaces that can accumulate moisture as part of their proper functioning or intended use. So that last part there, I think, is kind of important to focus in on. So for example, in a bathroom, there's going to be a lot of fixtures. There's going to be a lot of fixtures that will be damp through their intended use: sinks, bathtub, showers, the floor. So it's not going to be, if you kind of have a long bath, long shower, and you keep the room kind of tight and you don't air it out, that mold's going to happen naturally because it's the bathroom where there's going to be a lot of moisture to begin with. Similar to a kitchen sink, just make sure that you're staying vigilant on those types of areas and keep those as dry as possible so that the mold doesn't develop there. However, there's mold in a bedroom closet. That's a different story. Appliances are certain appliances are also subject to the warranty of habitability. By law, the refrigerator, range stove, or oven included with the residence for the use of the tenant pursuant to the lease agreement or any other agreement between the landlord and the tenant, those are going to be subject to the warranty of habitability. But the appliances have to specifically be listed in a written agreement or otherwise and actually provided by your landlord at the beginning of your tenancy. If your lease indicates that you get a refrigerator, range stove, or oven, and then it doesn't say anything about an air conditioning unit, but you have one in your residence, it's possible that it applies, but more than likely it may not. Okay, so again, this is another reason why housing matters aren't one size fits all, and they do require a case-by-case analysis, especially as everybody's lease is going to be just a little bit different. If you make a warranty of habitability demand based upon appliances, and your landlord replaces the appliance, then there's a presumption that that replacement is not installed in retaliation so long as it substantially has the same features as the original appliance. For example, if let's say that it's one of those fancy new smart fridges with a TV screen in it and everything, and about 2 months into your lease, the fridge dies and it gets replaced with a fridge without a TV screen. Well, that's not retaliation. It has substantially the same features. It's a refrigerator. It's still going to keep food cold. So it's not going to be retaliatory in that aspect, that the refrigerator has been replaced with just a less technologically advanced refrigerator. Another requirement of the warranty of habitability is that your residence can't have any condition that's going to materially interfere with the life, health, or safety of the tenant. This used to be worded a little bit differently. It used to be dangerous or hazardous to, but now it's listed as interferes with. It's a subjective standard, likely going to need some support for this position if you're alleging that. I think this also is kind of a catch-all that allows each of us as tenants to take into account our individual medical circumstances that are going to differ. So a condition that may not affect me may materially interfere with somebody else's life, health, or safety. And that's where this kind of catch-all provision comes from. So if the demand is made pursuant to a life, health, or safety request, that does alter a landlord's response and how quickly they must respond. So before we get to the responses, when is there actually a breach of the warranty of habitability? So we just kind of went through all of that list of requirements for things that have to be present or things that cannot be present in your home. But is that all? And the answer is it's not, because a residence, to be uninhabitable, it has to be described by the residence has to be uninhabitable. So uninhabitable means that it's one of those conditions that is described by statute, which we just went through the list, or it is in a condition that materially interferes with a tenant's life, health, or safety, and the landlord has received reasonably complete written or electronic notice of the condition and failed to commence remedial action by employing reasonable efforts within the required times. So what does this last part mean? What this last part means is that, say your landlord comes over and you guys are walking around the property or walking through the residence, and you point out a giant hole in the wall leading to the outside and say that's not supposed to be there, you need to fix that. Well, if you don't follow that up with anything in writing, then your landlord hasn't breached the warranty of habitability because your landlord's not received that written or electronic notice. So again, that's kind of going back to one of the first slides. Another example of why it's so critical to keep everything in writing as much as possible. So when does a landlord have to start fixing the problem after giving that written or electronic notice of the uninhabitability of the residence? 3 different timelines here to keep in mind. Life, health, or safety, one of those items from the list of conditions, or mold. When it's life, health, or safety, landlords have 24 hours to begin commencing remedial action to solve the problem. If it's one of those from the list, 96 hours to commence remedial action where the uninhabitability is due to one of those conditions: broken water, no heat, broken windows, no heat, no water, no locks on the doors. This 96 hours only applies if the tenant has included permission for the landlord or landlord's agent to enter the premises. So if you're providing your landlord with a warranty of habitability demand, just include at the bottom, I give you permission to come into my residence to fix this issue. What about mold? Well, mold's a little bit more detailed, and I just want to check the time here so we keep time for questions. So mold's similar to a statutory, one of the ones on the list, but there's more requirements than just the 96 hours. So within the first 96 hours, landlords have to install a containment stopping active sources of water to the mold. They also have to install a high efficiency particulate air filtration device to reduce exposure to the tenants. The landlord has to maintain that containment unit until they complete the following actions. Within a reasonable amount of time after installing that containment unit and that air filtration device, the landlord has to establish appropriate protections for the workers and occupants. They've got to eliminate or limit moisture sources, and they've got to dry all the materials. They have to decontaminate or remove damaged materials as appropriate, evaluate whether the premises has been successfully remediated, fixed, they got rid of the mold, and reassemble the premises in such a way to prevent any kind of recurrence of that mold from coming back. If you give your landlord that warranty of habitability notice or demand, do they have to give you a response? Yes, they do. They have to put something in writing to you. They have to give you some kind of response, some kind of acknowledgement of that notice or demand. Within 24 hours of receiving that notice, they have to respond to you in writing. It has to state the intention of remedying the condition, an estimate of when they're going to start fixing the problem, and an estimate on how long it's going to take to fix the problem. What about an alternative residence? Sometimes, yes. If the residence is in a condition that materially interferes with the tenant's life, health, or safety, and the tenant makes a request for an alternate residence, then a landlord has to provide one. A landlord has to provide either a comparable dwelling unit that's selected by the landlord, and that's at no expense or cost to the tenant, or a landlord can select a hotel room at no expense or cost to the tenant. A landlord's not responsible for any other costs that arise after that relocation period. A tenant's still responsible for the rent for the uninhabitable unit during that time. And again, this alternate residence accommodation only applies to material interference with life, health, or safety. So tenants, what can you do if your landlord breaches the warranty of habitability? Well, after you've provided that proper notice and you didn't get a response and or if your landlord didn't start any kind of remedial action or didn't finish it, well, you can terminate your lease. You can go to court to try to obtain injunctive relief. You can defend against an eviction for non-payment of rent if you've withheld your rent due to the warranty of habitability. There are also some other monetary options that we'll touch on a little bit. So one of the monetary options is withholding rent. So one of the things to keep in mind here is if you withhold your rent because your landlord has not fixed a warranty of habitability issue, keep in mind that it is not a warranty of habitability issue if you have not provided that notice or demand. But let's say that you've provided that and it hasn't been fixed, you are able to withhold the rent. Would recommend seeking legal opinion or advice before you take this step. One thing to consider is that if you are withholding the rent and your landlord tries to evict you for non-payment of rent, for you to be able to, go into court and say, I didn't pay my rent because my landlord breached the warranty of habitability, you will have to pay that rent that you were holding on to into the court registry. So if you're withholding rent, make sure you keep that set aside in the event that your landlord takes you to court to try to evict you for non-payment of rent. Also, you can bring a claim for the breach of the warranty of habitability outside of an eviction action itself. You're also able to deduct the cost of repairs for a breach of the warranty of habitability. This is an incredibly specific process. There are some risks involved in this process. It does not apply to everyone. You can't deduct for certain issues. I would seek legal advice before taking this action. It's a very it is a very specific process. There are penalties and consequences if it's not done correctly that are very drastic. So for example, as a tenant, if you wrongfully deduct rent, then your landlord will get a money judgment in that amount that you have wrongfully deducted, and you will likely also be evicted for non-payment of rent, barring some other defense because you didn't have a valid legal reason to keep that rent to deduct that rent in the first place. If it's more than a wrongful deduction and it's a deduction taken in bad faith, then your landlord, if they were to take you to court, would potentially receive an automatic eviction and then a money judgment for twice the amount that was withheld. So given the consequences here, if it's not done properly, I would strongly advise that you seek legal advice before even considering deducting the cost of repairs from rent when facing a warranty of habitability issue. Are there exceptions to the warranty of habitability? At the beginning of this presentation, when talking about unenforceable lease provisions, we did touch on this a little bit. It must be a written agreement that is separate from the lease itself. So it can't be just an extra paragraph in the lease. It has to be a separate agreement itself. The agreement has to be signed by the parties, and it has to be supported by adequate consideration, whether that's some kind of rent reduction or some kind of consideration, meaning that there was a benefit to both parties here. Because as a tenant, if you're waiving part of the warranty of habitability, you're kind of reducing what your landlord has to do. So if you're taking that burden off of your landlord, it's only fair that you receive some kind of benefit as well from this agreement. Additionally, tenants, you have to have the skills to perform the work. If you're not a licensed electrician, then you can't really be entering into any agreement that you're going to upgrade the electrical paneling of the residence because it's not in compliance with code or something to that effect. If you're unsure about whether this situation applies for you, again, please seek legal advice. We have resources available. You can contact the city, you can contact Colorado Legal Services. Just make sure that you seek out additional information before you take that next step. And again, other resources to reach out to: the Colorado Springs Planning and Community Development Neighborhood Services Office here in the city, the El Paso County Department of Health, and also the El Paso County Planning and Community Development Office for those outside of city limits in El Paso County. Also code enforcement, but things to keep in mind for code enforcement: they're not there to enforce the warranty of habitability. You're able to contact code enforcement, and there is going to be some overlap between the warranty of habitability and code enforcement, but not everything is going to be covered. One big example is mold. That is not included in the city code, but that is included in the warranty of habitability. You can call both, but the warranty, one way to think about it, the warranty of habitability is for the court and code enforcement is for city code. So two separate issues with under the same umbrella here. Let's move on to security deposits. And let's start with, when can your landlord keep your security deposit? Because when you pay a security deposit, that's not your landlord's money. That's money that's supposed to be held to kind of make sure that as a tenant, you follow through with your obligations of the lease. You're not damaging the place. You're making sure that you pay your rent and paying your bills related to the residence. But after you move out, your landlord is able to keep a security deposit for any damage beyond normal wear and tear, for non-payment of rent, if there's any abandonment of the residence, that's similar to non-payment of rent, any non-payment of utilities, repairs, or cleaning work contracted for you, for and by you. So, what is normal wear and tear? It is the usual deterioration which occurs when living in a residence. What is not normal wear and tear? So for just to kind of stay on this subject for this matter for just a second, usual deterioration. Carpets will fade after time. They will get worn down. That's what happens when you walk over them. Walls will get smudged. Counters will get smudged. That will happen. That's the usual deterioration, which is going to naturally occur. Well, what's not normal wear and tear? Careless or intentional destruction of property. A hole in the wall, that's careless or intentional. Carpet's going to be worn down by walking on it, but if you light it on fire, that's not normal wear and tear. So when you're moving out, this is when the security deposit matters are really coming into effect. So what should you do at that point? First of all, your lease probably says this as well. So also you're going to want to refer back to your lease as to what are my move out obligations? Do I have to schedule a walkthrough? Do I have to hire some kind of carpet cleaning? But generally speaking, I would advise that you clean the residence, do another walkthrough, take more pictures. If you have those pictures from the first time, from when you moved in, look at those and go through and try to take the same pictures again, showing what the condition is as you're moving out. Make sure that you return the keys to your landlord. And also this last part here is crucial, and that's to provide a forwarding address. How long does your landlord have to return your security deposit and or an accounting statement indicating the reasons why you're not receiving your full deposit? The landlord has by law, it's up to 30 days. However, that 30 days can be extended up to 60 days if it's specified in the lease. So again, as we're thinking about this, if you're on an oral lease and you move out and you paid a security deposit, your landlord has 30 days to return that deposit to you. So what happens if your landlord does not return your deposit? Just kind of bullet points here. Send them a demand letter. Send that letter via certified mail and keep a copy of the letter. Similar to the warranty of habitability demand letter, there is a sample letter in the renter rights packet that is available online. Here's just kind of a simple letter here, just indicating that these are kind of two. One is for a tenant who hasn't received any sort of deposit back, and another is for disputing certain deductions or withholdings from the deposit itself. Your landlord may only refund part of your deposit to you. They are permitted to do that. If they do that, they have to also include an accounting statement indicating the specific reasons that you did not receive your full deposit. Beware of what's called a restrictive endorsement. Sometimes an accounting statement will indicate that acceptance of this is a resolution, a full and final resolution of any and all disputes arising from this security deposit matter. And that would mean that if you accept that, then you may be giving up your right to go to court and challenge that security deposit withholding or security deposit deduction. If you do not receive a response to your demand, you haven't gotten anything, you send a letter to your landlord, you don't hear anything from, or your former landlord, and you don't hear anything from them, you can start a small claims action if the amount is under $7,500. For most residential leases, it's likely going to be under $7,500. I'm not saying it can't be, but it can't be more than that. But just in my experience, that's typically what I see as so far as what is a security deposit looking like. Well, it's going to be under $7,500 in most cases. If you file a security deposit action within a year, within that first year, then you can seek what are called treble damages, or 3 times the amount of the wrongfully withheld security deposit. One other thing on security deposits to bring up, I indicated earlier that it is crucial to provide that forwarding address to your former landlord. The reason that's crucial is your landlords and landlords on this meeting, you don't have an obligation to go find a tenant who hasn't given you a forwarding address. So tenants, if you've moved out and then you haven't provided a forwarding address, you don't have a claim for the wrongful withholding of the security deposit because you didn't provide your landlord with where they can send your deposit or that accounting statement to. Early lease termination. So what are some ways that as a tenant, that if things aren't working or if situations in life change, that you can terminate your lease early? It's permissible in, I would say, very few situations. Sometimes the lease itself has that actual language in it. So again, just another reason to make sure that you're reading through each and every line and paragraph of your lease, whether it's 2 pages or 60 pages. Just make sure that you see what's in that lease. You can also terminate your lease for a breach of the warranty of habitability. There are certain protections for the victims of domestic violence, domestic abuse, stalking, and/or unlawful sexual behavior, which would permit those tenants to terminate their lease. Military orders and act of God, earthquake, fire, lightning strike, so long as it was not caused by your own negligence. For example, if you're cooking something up on the stove and you go outside and you get kind of caught up and you're chatting with a neighbor, and your kitchen catches on fire, that's not going to be grounds for you to terminate your lease early without penalty. And your landlord may come after you for that damage itself. There's also an ability to terminate leases early if there have been multiple breaches of the warranty of habitability within 6 months. So if your let's say you have a heater issue or a water heater issue and you lose hot water today. You send the demand letter, landlord comes out and fixes it, everything's okay, hot water's turned back on by in a day or two, and you kind of keep moving along. Well, 3 months later, that hot water heater goes out again, and you're left without hot water again. At this point, you can just send your landlord a 14-day notice that you're going to be terminating your lease because this is the second time that your residence has become uninhabitable for the same condition. An exception here is that if it is an appliance issue, then you cannot terminate your lease early because of uninhabitability caused by appliances. So if your fridge breaks, landlord goes out, buys you a new fridge or used fridge, 3 months later, that fridge breaks, you can't terminate your lease based on that second refrigerator breaking. So shifting off of lease terminations and going into the Mobile Home Park Act. There are additional rights for tenants in mobile home parks who own their homes in the park. First of all, it is required that there be a written lease or rental agreement. And termination of the tenancy, it has to be for cause. And that's as opposed to ending the tenancy after the lease ends with what's called a notice to quit, which can be for any reason or no reason at all. So what constitutes cause for termination in a mobile home park? It's a long list. I'm just going to flash this up here just so because I know there's still some slides that we need to get through, and I would like to open this up for questions. But just to kind of summarize, cause in a mobile home park is that the home's not in compliance with local ordinances or laws relating to mobile homes and home lots. Conduct on the premises is unreasonably endangers the life of a person in the park, damages or destroys the property of a person in the park, constitutes a felony offense or class 1 or class 1 public nuisance and has been declared to be a class 1 public nuisance by a court. The park's condemned to change its use, not following the written rules and regulations in the park. Those can all be cause for termination. When can the park change its rules and regulations? If you agree to it, immediately. If you do not agree to it, then 60 days notice, and that rule will then go into effect. There have been some updates recently to the Mobile Home Park Act. First of all, the time a demand for compliance is now a 90-day demand for compliance, meaning that a homeowner has 90 days to cure an alleged lease violation or rule violation. If a park wants to serve a tenant with a notice to quit for cause, it must provide the homeowner with 90 days at that point to move or sell the home. Security deposits in a mobile home park can be not greater than 1 month of rent. There's no longer any sort of distinction between a single wide or a double wide. There's also a significant expansion and explicitly stating homeowner privacy. At this point, parks are not able to enter a homeowner's home without their permission and must provide prior notice of entering onto the lot site for work itself. And again, there are additional changes that we don't have the time for this evening. However, if you are facing an issue in a park, I would strongly encourage you to apply with CLS for possible services on the matter. There's also the Mobile Home Park Dispute Resolution Act. This is a mediation program that went into effect last year. And any party, meaning the park or the homeowner, may file a complaint with the Colorado Division of Housing. The division is going to investigate the complaint, facilitate negotiations between the parties. If they're unable to come to an agreement, then the division shall make a written determination of whether there was a violation. And then the determination must state the basis for it. For the determination, the violation, the necessary action to cure, the time to cure, the penalties for not taking the necessary actions, and the process for contesting the determination and penalties by means of an administrative hearing. If the determination is that there is not a violation, the written determination must include the basis for that decision and the process for contesting that determination. The party found in violation has 7 days to comply with a notice of violation, and if the party fails to do what's necessary to come into compliance, then that Division of Housing has the authority to impose financial penalties for each day that the party fails to do what was ordered. They can also issue cease and desist orders to stop an unlawful practice and can order a party to take actions to include refunding monies paid, filing documents that correct a violation, and or taking action to correct a violation. If you want to contest the decision, you may appeal by requesting a hearing before an administrative law judge, and that judge will hear testimony and receive evidence to decide on whether that prior decision is supported by what's called a preponderance of the evidence. Preponderance of the evidence meaning that it's more likely than not. At that point, the administrative law judge will enter an appropriate order within 30 days after the hearing and immediately send copies of the order to the parties. Moving on to forcible entry and detainer. This is eviction. So this is the legal name for the court eviction process in Colorado. Landlords, you must use the court process. As indicated earlier by Deb about the unlawful evictions. Unlawful evictions are evictions that take place without the court process. You cannot resort to self-help. You cannot change the locks. You cannot take off the doors. You cannot bar a tenant from entry into the residence. You have to go to court. The Forcible Entry and Detainer Act lists the reasons that a landlord can start an eviction action. The first step is typically receiving a notice to quit or a demand for compliance. As indicated earlier, a notice to quit is not based on cause, it's just terminating the tenancy. And a demand for compliance is alleging that there has been a violation of the lease, and it can be a demand for compliance for 10 days with a right to cure. However, if it is a subsequent violation, then you will not have a right to cure, or if it's an allegation of a substantial violation, a tenant does not have a right to cure a substantial violation allegation. There's no specific language required. Landlords do not have to use a state form required for the notice. Or the notice or demand, but they do have to include certain information. You have to describe the property. You have to have a date of the termination of tenancy for a notice to quit. It has to be signed. It must be served by statutory deadlines. For example, if you're a tenant on a month-to-month lease, you are entitled to 21 days notice for a notice to quit. If you are on a lease that is 1 year or longer, you are entitled to a 91-day notice to quit. And that 21-day notice to quit, that 91-day notice to quit, that must be served 21 days prior to the end of the applicable tenancy period. It's not just 21 days. It's 21 days before the end of the month. It's not just 91 days. It's 91 days before the end of the year-long lease term. Once the notice period, if you're a tenant and you get a notice to quit and you stay past it, or you get that demand and you're unable to come into compliance or to move out of the residence within that 10-day period or 3-day period if it's a substantial violation, then landlords are able to file a summons and complaint and then serve that on you as a tenant. So service, two kinds of service for a demand or a notice to quit. You have personal service, which is when it's handed to you in person, or if no one is home at the time personal service is attempted, a landlord may post it in a conspicuous location on the premises. That means that, kind of taping it on the front door, not hiding it under a mat, not crumpling it up and throwing it in a side bush or anything like that, but where somebody's going to be able to walk out and find it. If landlords are serving by posting, then at a court proceeding, you can only get a judgment for possession of the property and not any kind of money judgment. As a tenant, if you appear on that return date after a service by posting, then you waive personal service and your landlord is able to pursue a money judgment in the case as well if they prevail. So tenants, once you've gotten that, the summons and complaint, you have the option to file an answer in the case. The answer is your legal defenses in response to your landlord's complaint. Now, there are limited defenses, and not everything is going to be a defense. For example, there are going to be some tenants that are going to be affected by COVID, and that will not be a defense in court. And I'm speaking separate, I'm speaking kind of outside of the realm of the CDC moratorium, where it's clear that your life, your financial well-being has been affected by the pandemic, but your situation is not specifically accounted for in that moratorium. Even though you're kind of in that same kind of area under that same umbrella of being affected by the pandemic, legally you would not have a defense. And those are certain situations. If you have a concern that may be your situation, please reach out to CLS so we could take a look at your case. Can't promise that we can take every case that comes in, but it doesn't cost any money to apply. So please apply if you are concerned about that. Possible defenses in an eviction, we have the warranty of habitability. And this is beyond what was mentioned earlier as it relates to non-payment cases. So as a tenant, if you make a good faith complaint to your landlord or let's say code enforcement regarding the habitability of your residence, or organizing or becoming a member of a tenants association or similar organization, then you can assert that the breach of the warranty of habitability as a defense to the non-monetary eviction. for example, in this, kind of to illustrate this, if you give your landlord a warranty of habitability demand, and the next day your landlord says, Mr. Miss Tenant, here's a notice to quit. You gave me that warranty of habitability demand. You're going to have to go. Well, they're giving you, that's a bit of an extreme example because the landlord's admitting that they're retaliating against you. But it would be a possible defense to staying past the notice to quit, that the notice to quit was only given in retaliation for you as a tenant making a good faith complaint to your landlord or a government agency regarding the warranty of habitability. Make sure to appear at your return date. If you do not appear at your return date, the court will likely enter what's called a default judgment and you will be legally evicted at that time. Most courts are currently operating by phone or virtual hearings for cases. Depending on the county that your case is in, make sure to check the local court's current operating procedures. So what happens? So at this point in the FED case, if we kind of think about it as a timeline, we've received the notice to quit or the demand for compliance. We've had the, we've received that complaint, that summons and complaint. We've filed an answer. We've presumably gone to trial. Trials are to a judge, not a jury. And after a trial, the court has to make a determination on who has the right to possess the property. If the court rules that the landlord has the right to possess it, they will enter a judgment for possession. 48 hours later, the court will then issue what's called a writ of restitution. Now, this document, you see kind of a sample form that's up on your screen. This document is what allows law enforcement and your landlord to come remove you from the property and retake possession of it. It's when they get to come and they put your stuff out, okay? And I'm going to try to speed up a little bit here to get to questions. Fair housing issues. So fair housing, both at the there is Fair Housing Act at the federal level and the state level. It prohibits discrimination based on race, color, disability, sex, sexual orientation, including transgender status, national origin or ancestry, religion, creed, marital status, and or familial status. And now in Colorado, as indicated earlier, source of income. There are exceptions to fair housing. Owner-occupied buildings with 4 units or less, single-family housing sold or rented without the use of a broker, housing operated by organizations and private clubs that limit occupancy to members. Another exception is also 55 plus communities, 65 plus communities. And if those are an exception because those are permitted to kind of discriminate based on age, as it's really only looking for tenants of those age brackets. Very briefly here, there are service animals versus emotional support animals. Service animals are covered by the Americans with Disabilities Act. Specifically, a service animal can only be a dog or a miniature horse. It must be trained to do work or perform tasks. It is not a pet. A service animal is it is a medical device. It is an oxygen tank for legal purposes. It is a motorized, it is a wheelchair, it is a walker, it is a nebulizer. It's a medical device, it's not a pet. An emotional support animal is not covered by the Americans with Disabilities Act. There is a possible fair housing protection because an emotion support animal may be necessary based on an individual's disability. So in that situation, for emotional support animals, what I would recommend that you request what's called a reasonable accommodation. What is a reasonable accommodation? So it is discrimination to refuse to make a reasonable accommodations necessary to afford a person with a disability the equal opportunity to use and enjoy the residence. So what a reasonable accommodation is as a tenant, you are asking your landlord, based on my disability, I am asking you to make this accommodation, and essentially you're asking for an exception to the rules or some kind of some kind of addition so that you are able to get the same use and enjoyment out of the property as anybody else or as any other tenant there. Again, there's no magic language needed to make this request. There's no kind of specific state form. Landlords, if you say, well, you have to use my reasonable accommodation request, you're not correct. The reasonable accommodation request must be in writing, however, and it must state what the accommodation is that you are requesting. It can't be something vague of, I need you to make it right. It has to be, I am requesting, that I be given an assigned parking space in front of the building. I am requesting that I be transferred to a first floor unit. I am requesting that grab bars be installed in my shower, something where you're able to get full use and enjoyment out of your residence. There's, again, referencing those materials that are available online. There is a sample letter in the materials. Here's just kind of a draft of it. Again, just no special language here, just making the request. One key thing is you have to specify what it is that you're actually requesting. And with that, I will open it up to questions. Let me start working through here.
Thank you so much, Clinton.
So what is the exempt residential lease? That would be, as indicated earlier in the presentation, that exempt residential lease is going to be, it reduces your notice time from 10 days to 5 days is really what it does. That's what it is. It has to be specified in the lease agreement itself. So again, as indicated at the beginning of this presentation, I'm unable to provide legal advice, and this is not legal advice. So if you have a question specific to your situation, what I would recommend is that you apply for services with CLS.
And Clinton, will you identify which questions as you're going through?
I'm so sorry.
It's okay.
There was a question regarding allergies and smoke in the residence, and a landlord's lack of response, just to kind of illustrate why there's not a one size fits all in this kind of fact pattern. Would need to look at the lease, would need to look at any kind of communications between landlord and the tenant regarding what actions, if any, were taken to resolve this issue, and if there's any kind of grievance procedure contained within the lease itself. So this is the next question is concerning the tenant receiving a copy of their lease. What if only an electronic copy of the lease is offered to the tenant and the tenant is not able to access this lease? May the tenant demand a printed copy of the lease? Does the landlord have to comply? It's not really clear. If the file's corrupt, so I think by providing an electronic copy, that would be sufficient for the statute itself. However, if it's a PDF file or a zip file and you can't even open it, then I think at that point, that's a different situation where you'd be able to say, you gave me an electronic copy, I'm showing you that it doesn't work. Can you just print it out for me? So we've got a question that my rental has black mold. What can I do about it? As indicated, I can't give specific legal advice throughout this. We did cover the process for the warranty of habitability. So generally, when we're dealing with habitability issues, I would recommend that the first step as a tenant is to provide that warranty of habitability demand to your landlord. Regarding the rule requiring landlords to provide trash receptacles for tenants, my tenants purchase their own trash service at a single family home. The trash company they choose provides the trash receptacle. Am I responsible for paying some of their trash service? So again, as indicated earlier, I am unable to answer specific legal questions as they relate to the case. So again, this would be a situation where, whichever landlord posted this, I would need to talk to you about your rental property, review the lease, those type of matters, right? Also, I forgot, one kind of clarification point to make regarding the warranty of habitability. As indicated on that list of conditions, the common areas must be kept reasonably clean by the landlord, but that doesn't mean that they have to be, the floors have to be waxed every day or something like that. What that means is if the common areas get to a point where the landlord is the tenant is unable to use their residence for its intended purpose, then that's when the common area becomes makes the residence uninhabitable. This is a very good question. Thank you for asking this. What is the difference between notice to quit and eviction? I didn't get who is taking the action on the other. So to be very clear, an eviction happens in court. That's where an eviction happens. The legal terminology for an eviction is going to be the judgment for possession. A notice to quit is a document that is given that terminates the tenancy. And typically when we think about that, the notice to quit is coming from the landlord to the tenant saying, tenant, as of this date, your tenant at this address, as of this date, your tenancy is terminated, signed, properly served, and given with enough time. Tenants, however, can also give their this is, however, a mutual responsibility. Let's think of it as a month-to-month lease. If you're a tenant, you're on a month-to-month lease, you have the same obligation to notify your landlord, I'm terminating my lease, here's my notice to quit. So thank you for asking that. But the notice to quit happens before court too. So that's the document that the landlord gives to the tenant saying the tenant, you got to move out, or it's the notice given from the tenant to the landlord telling the landlord, hey, I'm not renting here anymore. I'm going to be out on this date. Again, if it's only when the notice to quit when the tenant stays past that notice to quit, that the landlord then is able to then go to court for a judgment for possession.
Do folks have other questions? It looks like those that are entered in the Q&A box, Clinton has gotten to.
So if we think of, just to kind of on that same subject, maybe this will draw out another question, but if we think of evictions as a broader umbrella or kind of steps to the last step being that writ of restitution, then the first step is going to be that notice to quit. And the staircase itself the entire staircase is going to be the eviction. The notice is just a step in the eviction itself.
All right, I kind of want to leave it open for another minute or two in case there are a couple of more questions. This has been really helpful, Clinton. Wow. Thank you so much for packing so much information into this one presentation. I'll just remind folks that we will be sharing the slides. However, you need to have signed up to give us your email address in order to receive the slides. So on the Justice Center's website, under Renter Rights 101 is where it says register for the renter rights. Even though this particular one has already happened, that registration form will still be open. So if you didn't already register and you joined this because you had the link, you want to go there and enter your registration information in order to receive the slides. We also will be posting the packet, the renter rights manual that Clinton talked about on the Community Development and Visions website. It's not up right now, but it will be tomorrow or the next day. All right, I'm seeing it looks like I have another question. Nope, no more questions so far. Great. Well, I just want to thank everyone again. I do want to finish up Thank you, Clinton. I'm going to go ahead and put up a last slide with some of the other resources that we've talked about.
Certainly, and again, I want to thank everybody for taking the time this evening to attend, and I hope to hear or virtually see you all at more presentations this year.
Thank you. So, sorry, I'm trying to talk and put this up at the same time. So here are some of those links that we talked about. Many of them have been put in the chat already. I want to thank again Deb Hamilton, Britt Kwan, Clinton, and also Catherine Duarte from the Community Development Division, who's been helping behind the scenes as well. We are going to be holding more of these sessions. So on the screen, you've got the other the dates at the bottom there. Please share these. Let folks know, your friends and family or anybody you know who might be interested. You can also, you'll be able to sign up for those future events on the Justice Center's website. You can also sign up for information from the Community Development Division at our website. We have a email newsletter, and we also will be sharing there the Renters' Rights Guide. Also wanted to mention on a closely related topic, many of you might have seen in the news that Congress appropriated $25 billion for emergency rental assistance back in December, and Colorado has received about $383 million for that emergency rental assistance. That will be available for people who are qualify with low income at 80% of AMI, area median income. If you've had COVID impact to your ability to pay your rent, and if you are housing unstable. The details for how people can apply for that money has not yet been put together, but the city, the county, and the state are working together to try to create a streamlined, simple process. And information about how people can apply for that will be available soon. We don't know exactly when yet, but it will be before the eviction moratorium expires on March 31st. So also, if you sign up for the newsletter at the Community Development Division, you'll be able to get information about that. Yes.
Barb, we did have one question come up here in the chat. And the question was, what are you seeing now? Are there many evictions? In all candor, in El Paso County, today was the first return date. Today was the first day the court had been open for a little bit. Towards the end of 2020, there was a statewide eviction moratorium, which barred filing in a lot of cases. So today was the first day that evictions were, there were return dates for evictions in some times. So I guess the answer is that it's a bit soon to tell. It's a bit soon to say at the current moment. I know that's kind of avoiding the question a bit. Last year, I believe I saw a statistic somewhere that El Paso County evictions were down, I want to say 50% to 2/3% based on various protections.
Thank you. Yeah, there is a fair amount of speculation, and there is some survey data about how many people say that they don't know if they'll be able to, or don't expect to be able to pay their rent. And there's estimations of billions and billions of dollars of unpaid rent in the United States, but those haven't been resulting in evictions as a result of the moratorium, we believe. So thank you for that, Clinton. And anything else from any of our presenters before we wrap up?
I have one last announcement. If anybody is experiencing difficulty paying their rent or mortgage now before the emergency rental assistance program from the Treasury is up and running, our division, using federal dollars, we fund several nonprofits who help with rent, emergency rent and mortgage payments. And I just put a link in the chat of some service providers such as Gretio, Family Promise, Catholic Charities, Westside Cares. So click on that link if you need help now before the ERA program is up.
Thank you for that, Catherine. All right. Well, thank you, everyone. We look forward to getting these resources out to you after the event, and feel free to contact any of us using any of the resources that we mentioned for further help. Thank you again, and I wish everyone a good evening.